Please make sure you study appeal preferences in 5521 that basically say that Articles 3, 7, 10, 10-A, and 1 and 2 of Article 6, all these social services law things, especially the rule that a motion for preference is not required. 4401. True, a motion for judgment during trial does not waive the right to a jury trial, even if it's made by all parties. And I have a note here that in 4401-A, it's a relatively new thing. It talks about a mandatory summary judgment for the defendant when a plaintiff in a med mal fails to introduce expert testimony. It's a specific type of med mal where basically you're suing because you didn't, lack of informed consent. But just read that. It's in there. It's kind of new.
And that's why my consent was not informed. And eventually that was changed to say, no, if you're going to try to prove lack of informed consent, you have to put an expert on who explains what in the medical community is considered for this procedure being adequate explanation to get an informed consent. And that's what it's about. Okay?
Okay, so 5011, which, if any, of the following are true, where damages are awarded to an inmate serving a sentence of imprisonment with, that just means upstate, or to a prisoner confined at a local correctional facility. 1, the court shall give prompt written notice to the Office of Victim Services, and the court shall direct that no payment be made to such inmate or prisoner for a period of 30 days following the entry of an order containing such direction. 5205 sub 8. In general, this is the car. It can't be more than $4,000 in value above liens and encumbrances, or $10,000 if it's equipped for a disabled debtor. But this does not apply if the judgment creditor is a state or it's for a support order. If direct, okay, this is 5205 sub 1. If direct deposit or electronically payments reasonably identifiable as statutorily exempt payments were made to the judgment debtor's account during the 45-day period preceding the date a restraining notice was served on the bank by a marshal or sheriff, $2,500 is exempt from application to the satisfaction of a money judgment. And all future payments that are coming from the exempt sources. Okay, so then basically the way that I memorized this next question in 5206 is that they lump Putnam, Westchester, and Rockland in with Long Island and the boroughs in New York City. So if you just can remember those 3 counties, it's obvious that it's more expensive to live in Long Island and New York City than everywhere else. So that's the big number, that's 150. With the counties of Dutchess, Albany, Columbia, Orange, Saratoga, and Ulster, 125,000. I haven't figured out a way to memorize that yet, so if someone has one, let me know.
Those are the counties around Albany. That's the capital district.
Okay.
That's what it's called. It's
and then the rest of the state where there's,
Albany.
you know, a bunch of farmland and prisons, that's 75,000. 5253, cost of living adjustment. Beginning on April 11, 2012, and at each 3-year interval, ending on April 1st, thereafter the dollar amount shall be adjusted with each adjusted amount rounded to the nearest $25. 5205, besides a wedding ring, a watch, jewelry, and art not exceeding $1,000 in value are exempt from judgment. Tools of trade, professional instruments, furniture in a library not exceeding $3,000 are exempt from a judgment.
Just stop for a second. Everybody look at me. The reason it says library, again, I told you these statutes go way back. In 1800, only the very wealthy had a personal library. That was extreme. An ordinary working class person, even a middle class person, might own one book, the Bible, and that was it.
Okay, I just want to make a point about that. If you're one of someone who is not interested in reading all of Article 52 and you're looking just to read a couple of things in there, where I would think that if OCA was thinking clearly where they would make a question out of that article is that they would they would ask something about the exempt payments. Someone whose bank account has been frozen. Think of a senior citizen who has no idea where this judgment came from. Their bank account is frozen. There's a bunch of stuff in Article 52 talking about go to the court clerk. You don't need an attorney. The court clerk may help you figure out how to get your money out of this situation. So I would just be aware what's exempt when it comes to the retirement, support orders, stuff like that, because there actually is stuff in there telling the people on the restraining note. If you look at the restraining notice and the notice to judgment debtor that has to be mailed out with the restraining notice, it has instructions on it that if you don't have an attorney, go to the court clerk and see if they can help you. So that's maybe, if you're not interested in reading the whole article and trying to memorize it, maybe just know what that part of it says. I get to skip, 61. Wait, where am I up to? Thank you. 4406, in addition to motions made orally or immediately after decision, verdict, or discharge of jury, there shall be only one motion under 44 with respect to any decision by a court or to a verdict. 5228, which if any of the following are true concerning a receiver appointed by a court to administer, collect, improve, lease, repair, and sell real or personal property in which the judgment debtor has an interest. 1, as far as practicable,
Just say 1, 2, and 3 are right.
okay, 1, 2, and 3 are right. 4 is wrong because it's not, 4 is wrong because the receiver gets a commission of not more than 5%, but not if the judgment creditor has been appointed receiver. 5230, in general, an execution shall be returned to the clerk from which it was issued on the support collection unit within 60 days after issuance. Okay, then skip 62 to 69, they are all not on the test. 70, 50, 19, a judgment order shall not be stayed, impaired, or affected by any mistake, defect, or irregularity in papers or procedure in an action not affecting a substantial right of a party. A trial or appellate court may require the mistake, defect, or irregularity to be cured. And then last question, 5525, within 15 days after receiving the transcript from the court reporter or any other source, the appellant shall make any proposed amendments and serve them and a copy of the transcript on the respondent. And then there's a 4-day notice rule relating to settling the transcript.